All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 3rd, 2021. We have 7 bills on the docket. We'll start off with Senator Jackson with Senate Bill 874. We'll then go to 657, 853, 905, 852, 752, and we'll wrap up with the Vice Chair with 862. So with that, Senator Jackson, you are up.
Thank you, Mr. Chairman. Mr. Vice Chair, for the record, Senator Jackson, Senator for District 27, on behalf of Senate Bill 874, Work Group to Study Partial Expungement. This is a fairly simple and straightforward piece of legislation. So work group I'm sponsoring on the Senate side, along with Delegate Eric Barron on the House side, House Bill 882. It establishes a work group to study and to develop both legislative and practical recommendations related to expungement of criminal charges that are not currently eligible to be expunged. The work group would be staffed by the Governor's Office of Crime Control and Prevention, Youth and Victim Services, and the panel would include 2 senators, 2 House members, a public defender or his designee, 1 representative of the Administrative Office of the Courts appointed by the Chief Judge. As drafted, Mr. Chairman, the bill states that the representative will be appointed by the governor. We have an amendment you should have in your possession that would change that to the Chief Judge of the Court of Appeals. 1 gubernatorial appointment from the Job Opportunities Task Force and the President of the Maryland States Attorneys Association or their designee. The numerous complexities with the issue of expungement, as we've seen with legislation over the years regarding justice reinvestment and other pieces of legislation we put forward. And it makes sense to put together a true stakeholder work group to examine those complexities as we move forward. As someone who's spent most of my professional life as a law enforcement officer, I think it's vital for us to show that making individuals whole is something that is just as important as anything else that we're providing service-wise in our community. In many cases, individuals spend their lifetime being defined by something, particularly in this case, of nonviolent crimes. This legislation will be a great step forward in providing a means to ensure that these individuals are not defined solely by the worst decisions that they made and are given a chance to make productive changes in their lives. With that, Mr. Chair, I'd like to ask you and the committee for a favorable report for this bill as amended. And with your permission, I'd like to bring in Ms. Karen York of the Job Opportunities Task Force to offer testimony. And together, I think we'd be happy to answer any questions. Thank you.
Excellent. Thank you, Senator Jackson. Ms. York, the floor is yours.
Thank you. Greetings, Mr. Chairman and members of the committee. For the record, I'm Karen York, Chief Executive Officer of the Job Opportunities Task Force, here to offer testimony in support of Senate Bill 874 as a means of facilitating the process of full repeal of the unit rule to ensure non-conviction records do not serve as a barrier to employment for Marylanders struggling to survive. It's no secret that the criminal record can serve as the cause and consequence of poverty for low-income workers, and it's well established that the impact is most pronounced among Black workers. For years, literally over a decade, JOTF and partners have stalkingly urged support from our state policymaking bodies to adopt policies that limit public access to the criminal record. Why is this important to JOTF? Many employers often refuse to hire prospective employees with a criminal record, even if they've never been convicted of a crime. According to the National Employment Law Project, over 70 million Americans possess an arrest or conviction record that will surface in a routine criminal background check. This means that there are over 1 million Marylanders who struggle to secure employment and higher wages due to a record, including ones that did not result in a conviction. Advances in technology have made it easier to access these histories. The record is no longer used solely in charging and sentencing decisions. It's now a key determinant in hiring decisions. As a result, Marylanders have found themselves shut out of the job market, and many apply for jobs for which they are well qualified, but do not have their applications considered because of a non-conviction record. Since 2015, the legislature has adopted a number of laws that would limit public access to mitigate the aforementioned challenges. Yet there was a technical outstanding rule that significantly limited expungement access, even when the law provided for it. This was the unit rule. a rule that prohibited expungement of eligible charges within a unit of charges, even if all charges within the unit were eligible. We saw expungement laws expanding, but thousands of Marylanders were unable to access and benefit from these new laws because of the unit rule. In our 15-year effort to repeal the unit rule, we were advised of a process called partial expungement that allows judges to approve the partial expungement of certain charges within a unit. Despite opposition advising that this was impossible, we found that not only was it possible, but it's already happening. In response, our focus was on partial expungement as a means of repealing the unit rule. After 15 years, in February 2021, repeal of the unit rule became law, opening the door for thousands of Marylanders shut out of the job market to move forward. Senate Bill 874 seeks to expand membership to the work group that was established within the legislation allowing for the full repeal. But Senate Bill 874 seeks to expand the membership in a way that ensures diversity in opinion and expertise among the membership. As the leading organization pushing for repeal of this rule for the past 10 years, JOTF requests to be added to the work group to ensure that there is at least one advocacy organization that represents the community begging for this opportunity. Additionally, as Senator Jackson mentioned, a sponsor amendment to provide for the chief judge to identify the judiciary's designee rather than the governor. This work group was not created as an opportunity to revive debate over whether or not the repeal of the unit rule should happen, or to limit who can benefit from the repeal. The repeal of the unit rule is currently in effect, and we look forward to working with our bill sponsors, the courts, and partners to ensure all who can benefit from this new law have the opportunity. Again, Senate Bill 874 seeks to ensure that we can move expeditiously and safely towards full efficient repeal of the unit rule using partial expungement, and we urge a favorable report. Thank you.
Excellent. Thank you, Ms. York, and thank you, Senator Jackson. So with that, that concludes the testimony for Senate Bill 874. I'll turn to the committee for questions. Seeing none. Just one thing, Senator Jackson. So we are in receipt of the two amendments, or is that correct?
You are, as a matter of fact,
we'll work them out.
I can actually, I do have the amendment numbers, yes.
Okay, excellent. That's perfect. So we'll get to work on it then. All
Yes,
right.
thank you.
All right, excellent. Thank you very much. Thank you, Senator Jackson. Thank you, Ms. York. And with that will conclude the hearing for Senate Bill 874. We'll now move to our Attorney General with Senate Bill 657. Mr. General, you're up.
Thank you very much, Mr. Chairman, members. It's good to be back with you. This is the last time you'll see me this session, I think. Article 3, Section 38 of the Maryland Constitution says, no person shall be imprisoned for debt. Yet in Maryland, people get arrested and put in jail because they have failed to pay a debt. This bill will very simply prohibit the arrest or incarceration of a person for failure to pay a small debt. Our Attorney General COVID-19 Access to Justice Task Force made this recommendation, and the bill will provide that small claims, those made in small claims court of less than $5,000, will not allow for body attachments for the arrest or incarceration of somebody who has failed to show up in court. The way these arrests happen is that after having a judgment, often by default, perhaps usually by default, entered against them, a debtor may be summoned to court to answer questions. They don't understand, they don't get the notice, they figure they can't take time off work, they don't have the money anyway, they don't show up. The result is that a body attachment issues, an arrest is made, and the folks are brought to jail. Sometimes they end up being there for a while. I remember working on this issue back in 2013, and the year before, somebody had been arrested based on a body attachment. I think he owed $15,000. He was put in jail and he was there for 5 months. That's totally unnecessary, and the practice is often unconstitutional. When I say unnecessary, creditors already have very powerful tools. They can garnish a debtor's wages. They can put a lien against the debtor's property, garnish a debtor's bank account, take a debtor's car. But the theory behind this interrogatories in aid of execution is that they need to bring the debtor to court to find out where the debtor's assets are. And the fact is, it's easier, simpler, and probably less expensive to do it through modern means, a credit report. There are a number of different agencies that know not only who we are, where we last bought our last tank of gas, what we ate when we last went to McDonald's. And the fact is, it's much easier to find out where a debtor's assets are that way than it is to drag the debtor into court. You'll hear from someone who's been arrested and locked up for being in debt. You'll hear from Jeffrey Abney, who's a University of Maryland student who participates in the Consumer Law Clinic. Just a handful of lawyers use this interrogatories in aid of execution process disproportionately. It's not used by most lawyers who collect debts. You'll hear that debtors subjected to this treatment are overwhelmingly Black or brown. They're all low-income families. The bill, as I said, only covers cases in small claims court, so doesn't apply to debts over $5,000. Ironically, just about every debtor has a statutory exemption from execution of a judgment for $6,000 of cash or property. It's Courts and Judicial Proceedings, Section 11504. Most debtors don't know they have this exemption. They don't say the magic words. They don't file the right papers. But a small claims court case is almost by definition exempt from execution. So we're asking you to stop the arrests, stop the incarceration, and please give a favorable report to this bill. Thank you very much, Mr. Chairman. I look forward to your questions.
Excellent. Thank you very much, Mr. General. I'm looking for Ms. White. I don't see her in the room, so we'll move then to Mr. Abney. You're up next.
Thank you, Chairman. As said, my name is Jeffrey Abney. I'm a third-year student at the University of Maryland, Carey Law School. During the last year, our Consumer Protection Clinic conducted a study about judgment creditors' use of body attachments in civil debts in Maryland. We discovered that from January 2015 until December 2020, at the request of judgment creditors, Maryland judges issued at least 765 body attachment orders. 6,000 of debtors' cash or property is already exempt, as the AG mentioned. That means that creditors cannot reach that $6,000. The average judgment is for a little over $5,000. Also, these debtors must affirmatively assert this exemption in court, which many do not have the ability to do by themselves. Based on an analysis of zip codes, these creditors disproportionately use body attachments against low-income people of color. The 20 zip codes that have the highest numbers of body attachments contain over 81% people of color. Same zip codes also have a median income of $49,000, well below the state median income of $83,000. Most creditors in the state use wage garnishments or property liens as the debt collection method of choice, as AG Frosch already mentioned. The types of creditors that most commonly use body attachments are finance companies, municipalities, realty companies, credit unions, and homeowners associations. Arrest on body attachment warrants can occur soon after the issuance of the warrant, or some can come months or even years later. During these periods of time, the person is subject to the arrest, most times without notice. In sum, our study shows that creditors are using body attachments against a significant number of debtors, most of whom are disproportionately low-income people of color. Many of these judgment debtors either have no assets or have statutorily protected assets and are still arrested and jailed or made subject to arrest for indefinite periods of time. Because of these things, I strongly urge the adoption of Senate Bill 657. Thank you very much.
Excellent. Thank you very much, Mr. Abney. We'll now move on to Ms. Adams. Are you here?
Hi, good afternoon. Thank you, Mr. Chairman. My name is Cecily Adams, And I'm here because I was arrested November 12th, 2020, because of a court case filed by attorneys representing my homeowners association for past due HOA fees, fines, and legal fees attached to that. It's difficult to be here, but I feel like it's important to be here because my case kind of turns out as a, I don't know, best case scenario. I'm an active community and family member in Montgomery County with a strong volunteer history and no criminal record. And I think this is important because my arrest then was not, did not have me detained for longer. My legal case with my homeowners association came to a head when I didn't receive notice of a hearing in September of 2020. And when I saw on my cameras that there were 3 armed officers at my door to arrest, and what I found out later was to arrest me. After some phone calls to the sheriff's office, they let me know that there was a body attachment order tied to this case that I was fully unaware of prior. And it was in that conversation that I also found out, the reason. Let's be clear that this was November 2020 in the middle of a coronavirus surge. And I was still told that I needed to report to the courthouse to turn myself in, which I did. I was handcuffed in the lobby of the courthouse and taken, processed, and then brought before a judge, in which case I was then allowed to leave. It's important for me to share this story because I am here as a legal US citizen. I don't have a criminal record, but this situation could have gone very differently for anyone else. And that I feel that that is those conditions that allowed it to turn out well. We also know that we're in the middle of a moment where just legal police intervention puts risk when those people are showing up at your door. And it's been extremely traumatic to reflect on what could have gone horribly wrong in that situation.
Ms. Adams, thank you very much for sharing your testimony, your story, your experience. And thank you for being here, taking time out of your day. I see that Miss White is here. So we'll hey, how are you? Good to see you. You're up next.
Hi, good to see you. Sorry, I was in finance, so I've been bouncing around a little bit in Zoom rooms. Thank you, Chair, members of the committee. For the record, Marceline White, Executive Director of the Maryland Consumer Rights Coalition, MCRC, and MCRC advances economic rights and financial inclusion through research, education, consumer outreach, and direct service. And we're here today in strong support of Senate Bill 657. As you know, and this body knows, this is an important issue that we've all been working on and discussing for several years now. But SB 657 makes good on the ideals promised and embodied in our Constitution, which says that we do not jail people for debt. And this will remove that entirely from our practice. I do not want to repeat what other people said, but I will follow up and send the committee some stories of Marylanders who have been jailed as recently as 2016 after other legislation has been passed. I'm sorry, I didn't make it into my written testimony. But I do have stories of a Mr. Hasty who was arrested in front of his children for an $89 vet bill. Mr. Brian B. of Essex, who was in jail for a day and a half while his elderly mother scraped together money to pay his bond. And a Mr. Spann, a 69-year-old gentleman from Prince George's County, who was arrested 2 times and jailed, even though he had no money that the court could actually take or garnish from him, and he had declared it twice. In terms of right now, this is an important moment to enact this legislation. Obviously, we're in a public health crisis, and with COVID-19 and the pandemic, the last thing we want to be doing is jailing additional Marylanders, especially because they owe a debt under $5,000. Secondly, from other work we've been doing in the General Assembly, we've seen recently that Marylanders have been jailed because they owe a medical debt that's under $5,000. So we shouldn't be jailing people because they sought medical treatment and couldn't pay their bill and then were put in jail. This makes no sense. It's an economic justice issue. These debts fall primarily on lower income Marylanders, and it criminalizes poverty by creating a two-tiered system of justice. It has no constructive purpose. People are not served by being in jail. They didn't harm anyone, and they are not a danger to the community. Moreover, if they're jailed, they may leave children unattended, they may lose an hourly wage job, which will make it more difficult for them to repay any debts that they do owe. Finally, I just want to say this legislation, and the original interrogatories comes out of an older time. It's kind of an archaic law at this point because the debt collectors have other ways to find this information. They don't need a written form. There are other things they can do, as you can hear from other folks. So really, we need to have the debt collectors modernize and use the new technologies that are available rather than putting people in jail. I just think this is an important opportunity to meet this moment and finally declare that Maryland no longer jails people for small debts. And for all of these reasons, we support Senate Bill 657 and ask for a favorable report. Thank you.
Excellent. Thank you, Ms. White. And we'll now move on to Mr. Schlee. Mr. Schlee, you are unmuted, but we cannot hear you for some reasons. There you go. You're unmuted. Let's try it one more time.
How about now? Can you hear me now?
There you go. Perfect.
There you go. Sorry about that. My name is David Schlee. I'm the president of the Maryland DC Credit Bar. Thank you, Chairman, for giving me a chance to speak on this subject. We're an association of 40 law firms that does collection work for banks, credit unions, debt purchasers, and different large national banks. We normally come here and testify. Usually me and Ms. White and some of the others here, we're not always on the same page, but this is a moment where we all do agree on one thing, which is the use of body attachments in small claims cases. As a national organization, nationwide, we've actually asked other states to prohibit this action. And we also asked them today that we join together and have opportunity to take a practice that has been sort of an older practice. There was some mention, Marceline mentioned, Attorney General Frosch mentioned, that there are plenty of other techniques to find people, and there are low cost techniques. There are a lot of ways to find different things, especially at a, if you're a national bank or if you're a large debt purchaser, a large law firm, you can use those practices that are rather inexpensive. So, most of what you see nowadays in the way of this practice is on individual small debtors or small creditors. For these reasons, we ask for a favorable passing of this bill. Thank you.
All right, thanks. Thank you very much, Mr. Schlee. We can make Vice Chair Wallstreicher, we can give him the admin privileges. I think that's what the problem is there. But thank you very much for your testimony. With that, that'll conclude the testimony for Senate Bill 657. We'll turn to the committee for questions. Senator Hettleman, you're up.
Thank you very much, Mr. Chairman. I'm just wondering, I was just going through the testimony a little bit. I wonder, and I'm going to guess direct this to Attorney General Frosch, and I don't mean to put you on the spot, but I'm sort of curious about the judiciary's opposition here, and especially in light of the testimony that we just heard from Mr. Schlee. And I just wondered if you could comment on that, because I think this is a terrific bill, and I just think these practices are antiquated. So I'd love to hear what you think.
Right.
Thank you.
I mean, I hate to be on the other side of the judiciary. They feel this infringes upon their powers. They think it's a separation of powers issue, and we disagree. We think that the practice itself is unconstitutional because of the provision of Maryland Constitution that says nobody can be imprisoned for debt, and disagree with them that this is a constitutional problem vis-a-vis the separation of powers. And that's the best I can tell you.
Thank you.
All right. Any other questions? Senator Carter has a question.
Thank you, Mr. Chair. Thank you, Attorney General Frosch, and all the witnesses. I just wanted to express my deep appreciation for the bill as well. Also to apologize to, I don't see her anymore in the room, but the witness that had the courage to come forward and talk about her story, her horrific experience of being arrested. That's got to be completely demoralizing and humiliating. I actually had a client myself a little bit more than a year ago who had the same situation. He was arrested for ostensibly a failure to respond to interrogatories regarding a car repossession that had happened like more than 15 years before. It was all a mistake, but nonetheless, he was actually arrested for that. I'm shocked that we haven't fixed this yet. I'm wondering where we fall in terms of other states that allow this to happen. But I'm fully in support. I'm just wondering, why we're so behind the 8 ball on this. Like, why are we so slow in fixing this problem?
Senator Carter, if that's directed to me,
Yes.
Many years ago, not so many years ago, when I was in the General Assembly, I gave it a shot, or two, I don't remember, but was unsuccessful. It's been on the radar for many years. We've been chipping away at it. This is a bigger chip. This is all small claims cases. Does not address claims of over $5,000. I know there are other states, and perhaps Marceline White has more information on this. There are other states that have abandoned this archaic practice, but it's still in effect in many states even today.
Thank you.
All right, Senator West has a question.
Thank you, Mr. Chair. It's always great to see the Attorney General, and it's unfortunate that I always find myself asking critical questions. So actually, I've never tried to collect a small claim debt, but my understanding is the way it works is once the debt's there, you can notice a deposition in aid of execution, and if the debtor fails to show up, then you go to the court and you get the court to enter an order ordering to show up. And then again, if he doesn't show up, then he's in contempt of court and the sheriff can go out and bring him in. So that's sort of the predicate for this.
Correct.
My understanding is once he's brought in, the attorney is called and the attorney goes and then sits down with him and puts him under oath and asks the questions, which he has to answer under oath. And then once he's answered the questions, he's free to go home. It's not like it's a long jail sentence. Am I not right on that?
Well, I think you're right up to the very end.
Okay.
Because there are folks, the attorney may not be available on a moment's notice and doesn't show up. You get sheriffs going out and dragging the debtor into the courthouse. The attorney for the opposite side may be in the Bahamas, and then the court sets bail for the debtor, and often the court sets bail in the amount that the creditor is seeking, which to me seems precisely to violate our Constitution. I mean, then you're in jail for debt, and your ticket out is whatever the creditor is asking for. Otherwise, I mean, I think what you described is pretty much the process. But as you heard, Ms. Adams didn't get noticed. That's the way it works. Unfortunately, it's a surprise. Somebody, law enforcement officers show up at your door and demand that you come to court immediately. Sometimes they handcuff you at your home or your place of business or school. And sometimes they wait until they get you to the courthouse. They handcuff you. They then bring you before a judge, if a judge is available. And a judge isn't always available. So, people do spend time behind bars. As I mentioned, just to refer back to Senator Carter's question, I introduced a very similar bill in 2013. And the year before, or just a few months before, there was a guy who owed somebody $15,000. He either purposely failed to show, but more likely didn't get noticed, didn't think he had the money, or was unable to show up on the day appointed for the interrogatories, and was arrested. I don't know why he was held over, but what I heard subsequently is the court system lost track of him. He spent 5 months in jail for owing somebody $15,000, and it's totally unnecessary. And the interrogatories are questions that are pretty much useless for claims under $5,000. Most of these people don't have bank accounts. The creditor knows where they work, knows oftentimes where they're banking if they have a bank account, and can take all kinds of actions and get better information than the debtor is able to give them. I mean, if somebody said to you, what's the number of your bank account? I'm guessing you wouldn't be able to give it to them.
I would have no idea, but I would know the bank that I bank at.
Yeah, well, so would I.
And provide that, and they could serve a writ of garnishment on the bank, and that's an easy process.
Yes, and they know it before they have to ask the question. It's easy for them to find out. I think Mr. Schlee said on the House side, it costs $25. You get the person's bank account number, bank, you can garnish it.
Right, but you got to get the bank. Not so much the account number. Most garnishments don't specify the account number. They just tell the bank, if you have the account in the name of John Smith, you need to garnish the account.
Yeah, I mean, that's true. What I'm saying is, for $25, they can get that information. They don't need to have a lawyer show up and do interrogatories and aid of execution.
But how do they get? I'm sorry. How do they get that information for $25?
Mr. Schlee can explain in detail, but there are credit reporting agencies and other kinds of credit agencies that can tell you, does Brian Frosch have a bank account? If so, at what bank? What's the number? How much has he got in it?
Interesting. I didn't know they were so intrusive. So if I have a bank account at some relatively unknown bank with one branch out in Harford County, Maryland, somebody could pay a credit reporting agency, and they would know, they'd be able to find out that I had that account at that branch in Harford County.
Yes. I'm not sure. I said they'd know how much. I'm not sure they know how much, but they would know you have that bank account.
Okay, I'm sure they don't know how much. I think that kind of information is protected. But
there's so much information about all of us on the internet at this point. I mean,
yeah, I know. It's really too bad. All right. Well, thank you for your answers to my questions.
It's always a pleasure, Senator.
It is indeed.
We love having you back, Mr. Attorney General. Senator Casserly has a question.
Thank you, Mr. Chairman. Good afternoon, Attorney General.
Hi. How are you, Senator?
Yeah, I'm good, thank you. Now, I know I think it was last year, either we changed the law or the Rules Committee changed the rules on in this whole area to allow for written questions to be sent out and person to simply mail the stuff in and avoid coming in. And as long as they mailed it in, there was no issue, correct? I mean, something along those lines. It was a super friendly process. So people didn't need to take off from work, didn't need to come into court. And you could just sign the form under oath and say, here's the information. And in fact, I think it's a templated list of questions that the Rules Committee came up with. You recall that?
I think that's right. And yet some people are still, the person may get it in the mail, may not get it in the mail. But some people are still demanding that they show up in court.
So I was surprised. I went through the committee file. I saw there was no opposition to this. I thought that, I mean, you work this out. I mean, the debt bar is fine with this. I don't want to make problems if there's no problems. I mean, if they're like, hey, thumbs up, we're okay, then I'm walking the heck away real fast. So
yeah, I mean, Mr. Slee represents the creditors, a creditors bar association. I think it's pretty widespread, and you see, I mean, the judiciary has opposition because of the separation of powers issue. But
no, and I got that, and I guess their concern is don't give us the power to issue orders, and so we can't back that up with contempt, which certainly makes sense. But if we're taking away the authority, they will never run into this again, right? I mean, if you can't issue it, there won't be a violation. If we're going to give the power to, if we're saying you can do this and they do it, and then there's no remedy, then. But if it's not a power, then there's no right. I mean, I can't run afoul of a law. There's no reason to hold me in contempt, right?
That I agree with you. Yes.
I mean, I'm okay. Well, maybe I should just ask Mr. Slee then, because I'm sorry, maybe I wasn't paying quite full attention to realize who he was representing there. And I appreciate your answering my questions, Mr. Attorney General. Thank you very much.
Thank you, Senator. Appreciate it.
If I could just hit Mr. Slee up to respond to that, I'd appreciate it. I'm sorry, I missed you.
No problem. So I will tell you up front that almost everyone nationally, debt purchasers, banks, our national organization, everybody, and especially since COVID-19, the PR involved, first thing, the reality is very little money is collected with body attachments. Okay, most people don't have any money. Two, the PR involving cases, and I know there were some things mentioned. There are people you can be pulled over at any moment. It could be Saturday night, and you have 3 kids in your car, and you could get stuck in hard. So you have these cases with a $500 debt that goes on, and so the banks, they prohibited these practices years ago. No one's doing it, and I will tell you that the rule that was changed has not worked very well. And I got to be careful. I go to court all the time, so I don't want to go too much against the judiciary. But I will tell you up front that it's not working very well, and people are not doing those interrogatories because the fear is you will end up to a body attachment and then have, be in the Baltimore Sun the next day about how you have somebody stuck in Baltimore City jail for 2 days on a $500 health care bill. Okay, so
yeah, I can understand why
the practice isn't even happening anymore.
Yeah, so, I mean, and I can understand why the big folks don't do it. That the people looking for healthcare debt. I mean, in my experience, the local folks do it. The local grocery store, the local business person, to whom 4 or 5 grand is big money, and you got a debtor who just won't respond to stuff, and I don't have your social security number, so I can't get a credit report. And if I just ask for a credit report on Joe Smith, it's, there's all 50,000 of them, and which one are you talking about? And so these are commonly used. I mean, I would be concerned about the specific cases where, that they'd be subject to misuse, but I thought we had addressed a lot of that.
Again, you're right. I'm representing large organizations.
A large organization.
Banks. Yeah, I mean, but I do have some firms that are smaller that have all agreed to that a lot of people have pulled back from that process. But you're right. If an individual person and it's under $5,000 wants to sue individual B, and they don't have those tools available to them, that, you know, and I think it's a public policy decision at that point. Like that's, you know, I think, you know, that's where we're at with that.
Yeah, I mean, just interesting because we want people to do business with people that aren't really wealthy. But what we're saying is, look, if I do business with you and you're really wealthy and we do a $30,000 deal, then I can come after you and I can do all these things. But if I do business with you and you're a small guy and it's only $5,000 debt, then I'm rolling the dice. It's just, you know, this is public policy, but we're taking a big public policy because I keep constantly hearing, hey, you're not giving credit, you're not doing business with people and these other, you know, who have lesser means. But if you say, yeah, but the risk of doing business with these people of lesser means is really high, because unless you get their social security number and their date of birth and their driver's license number and everything else right up front, then you can't collect on the back end. So you sort of create two standards where the guy that walks in a suit gets treated one way and the blue collar guy gets treated another, and you got to basically require a full financial disclosure coming in, because your only hope of collecting if he doesn't comply is to do all these attachments. But I mean, if that's the public policy, I just don't think that we ought to be surprised when, you know, over ensuing years when people demand an incredible amount of disclosure on matters that are $2,000 and $3,000, and you're saying, why do I have to give all that? It's like, well, because my only choice. I can't. If you don't pay, I have no courts to go after. I have to do all these private means and therefore fill out these 4 pages and everything about you. But okay. Hey, it's public policy, Joyce. Thank you. Thank you, Mr. Chairman.
All right. Thank you to all. I'm looking around the Zoom room to see if there's any further questions. I do not see any. So that concludes the hearing for that bill. Thank you again, Mr. Attorney General.
Thank you, Mr. Vice Chairman, members.
Move on to Senate Bill 853, Senator Carter. Everyone's bouncing around. There you are, Senator Carter. Go ahead.
Thank you, Mr. Vice Chair and Acting Chair and members of the committee. It's truly my pleasure to present this bill, Senate Bill 853. I'll do a brief introduction because I have a really esteemed panel consisting of Secretary Abed, Martin Nelson from the Vera Institute, and Jenny Egan from the Office of the Public Defender. But all of these panelists were members of our Juvenile Justice Reform Council, and this bill is the product of the Juvenile Justice Reform Council. And so they will talk more about it. I'm going to walk through basically the basics of why we need the bill and some of what it does, and then I will turn it over to them. But I also want to acknowledge that our own committee members, Senator Chris West and Senator Michael Jackson, who was then Delegate Michael Jackson at the time, were all members of this Juvenile Justice Reform Council and all took votes in favor of many of the policies that have now been reduced to legislation in Senate Bill 853. So Senate Bill 853 seeks to establish best practices regarding the treatment of children subject to Maryland's criminal and juvenile justice systems. The bill is the result of 2 years of the Juvenile Justice Reform Council's study, discussion, and debate on a wide array of issues facing Maryland's juvenile justice system. All of the recommendations included in this legislation were approved with overwhelming bipartisan support. All but one passed unanimously. To highlight some of the particulars, Senate Bill 853 would prohibit the use of detention for technical violations of probation and for certain misdemeanor offenses in favor of a community supervision or GPS monitoring. It would also require courts to review the detention status of juveniles every 14 days pre-trial. The legislation also provides for informal adjustment, which we've also looked at year after year, but we've not moved on it, as a matter of course in most minor cases, which research has shown can be extremely effective in preventing recidivism. Lastly, the bill outlines reporting requirements for the Governor's Office of Crime Prevention, Youth and Victim Services and the Department of Juvenile Services, and supports the creation of a work group to inventory and report on evidence-based programming. These recommendations serve to create more conscious consideration of a child's age and development before, during, and after sentencing. To reach effective solutions, we require targeted, robust data from communities where children are most at risk to ensure their needs are prioritized. The answer to these issues cannot continue to be putting disproportionate amount of Black and brown children from low-income neighborhoods into an already overcrowded system. A system which is ill-equipped to address children's needs cannot adequately protect them. If we cannot offer support, protection, and meaningful rehabilitation programs to our youth, we are not only setting them up for failure, but we are putting their very lives at risk. We've heard many times during this legislative session that in an all-state survey, Maryland was ranked last and among the absolute worst states in the human rights of children regarding specifically how we treat children in our juvenile and criminal justice systems. This bill, this comprehensive bill, will go a long way toward moving us hopefully from last to first, but certainly rectifying a lot of our problems. For these reasons, I would ask for a favorable report and look forward to hearing from the various members of my esteemed panel. Thank you.
Thank you, Senator Carter. Mr. Secretary, thank you for joining us today. Go ahead.
Thank you, Mr. Chairman and members of the committee. Sam Abbott, Secretary for the Department of Juvenile Services, and I'm in support of Senate Bill 853. It was an honor to chair the Juvenile Justice Reform Council. I'd like to thank the 34 people in total that served as members over the last 2 years. The council membership was broad. It included every child serving agency, the public defender, a representative of the State's Attorneys Association, experts, national experts like Marta Nelson, who you'll hear from, and her team from the Vera Institutes of Justice, as well as the Annie Casey Foundation, academic researchers who specialize in youth justice, advocates, practitioners, and 2 young people who have been through our system. As Senator Carter already mentioned, we had members from this committee as well. In addition to Senator Carter, Senator Jackson and Senator West were active members of the council, highly engaged, attended, participated in the meetings, and took a lot of time because we did work our council members pretty hard with a lot of information and to synthesize all that information and come back with recommendations and the discussion is very much appreciated. We also had 16 listening sessions that were organized by our local management boards covering every region of the state. And we had 530 members of our community take the time to personally share their viewpoints with us. And we were very fortunate to finish all of our listening sessions in person. However, we were interrupted by COVID in March. It did delay some of our meetings and we had to redouble our efforts, but we did reboot online and we finished most of what we set out to do. I believe Senator Carter mentioned this, but we did issue a final report in January, and it details the areas that we think, as a council, additional review is needed. But the bill that we have today, that comes before you today, brings together all the substantive recommendations that we were able to actually take in and consider. And these recommendations were thoroughly vetted. And the data was weighed, and all of these policies were carefully weighed. While the council wasn't able to complete an entire review of the system, this covers a large portion of it, and it sets, as Senator Carter mentioned, minimum age of jurisdiction. It puts guideposts for the administration of probation cases, and it prioritizes intervening with community-based responses over the use of detention or committed placement. I'd like to emphasize that while it is an ambitious package, what you see here was very broadly supported by our council members. And we speak as a body, just like the legislature does, and just like the Supreme Court does. And sometimes you've got to look to those, the counts in the decisions. Is it a 5-4 decision, or is it an 8-1 decision, to kind of see the strength? And I just want to emphasize that these were not close calls on the recommendations that passed. These were very broadly supported. Most of them were unanimous. If we had opposition, it was either 1 or 2 votes of opposition on the substantive recommendations. And the other way I like to look at consensus across the group is to look at the 2 polls. within the group. And our public defender, Jenny Egan, who you'll hear from, as well as our state's attorney's rep, Scott Schellenberger, voted positively for all of the recommendations, the substantive recommendations that we have in this bill. So we had a diverse group informed by 530 of Maryland citizens, national experts, informed by each other. And then we all coalesced around these recommendations. And I think that that's a very powerful statement of support for Senate Bill 853. I fully support the recommendations, and the Department of Juvenile Services will move swiftly to implement this bill should it come into law. And for these reasons, I ask for a favorable report. Thank you.
Thank you, Mr. Secretary. Appreciate your testimony. Ms. Egan, you are next. Good to see you. Not on Twitter. Go ahead.
Thank you, Vice Chair. I appreciate it. And thank you, members of committee, especially Senator Carter, Senator Jackson, and Senator West, who worked so hard on the JJRC. I am here to tell you that adolescence is a time when children start to ask, who am I in the world? And I'm here to tell you, despite their rolling their eyes and staring at their iPhones, the teenagers in your life are very much listening to what you tell them in response to that question. When we put handcuffs on a child, when we put a young person in a cage, we are most assuredly sending them a message. This is who you are. This is what we think you deserve. And that message has been sent overwhelmingly to children in Maryland who are Black. The fact is, the vast majority of kids who commit crimes grow out of it on their own without any system intervention. A quality juvenile justice system is one that allows those children who will naturally mature past bad misbehavior to do that and move on, and to reserve the system for targeted high quality interventions for the very small number of young people who need more support to successfully transition into adulthood. But for too long in Maryland, we've had just the opposite. We've had a system that criminalizes low-level childish misbehavior and treats all kids with the same broad brush. According to a study commissioned by the Department of Juvenile Services, 2/3 of kids removed from their homes in Maryland had not committed a felony offense. Those are children that are taken from their families and their homes. The JJRC learned that incarceration-based placements for young people are not only expensive, but can actually worsen outcomes compared to results for similarly situated youth who receive their services in the community. Specifically, youth prisons are linked to higher rates of recidivism, particularly for more serious offenses, increased likelihood of incarceration as an adult, higher high school dropout rates, decreased educational achievement, and decreased likelihood of future employment and earning potential in the labor market. For years, Maryland has spent resources on policing and incarcerating children for behavior that not only does not need court intervention, but done so knowing that that court intervention and incarceration is making us less safe. That's a major reason that Maryland was ranked as one of the worst states in the country for protecting children in the criminal legal system last year. This bill is a historic opportunity to take the first steps to correct these long systemic problems. The JJRC was able to dive deep into these sticky, difficult issues to come up with workable, pragmatic, bipartisan solutions that make our communities and Maryland as a whole stronger, more vibrant, and more safe. This bill does 4 major things. It raises the minimum age of juvenile. Yes.
Thank you. If you want to conclude, go ahead.
Absolutely. It raises the minimum age of jurisdiction. That was removed in 1994, which means that kids as young as 5 and 6 can be arrested and charged in Maryland. It limits probation to finite terms that young people can understand. It bans youth incarceration for low-level misdemeanor offenses and by technical violations of probation. And it removes some of the barriers to diversion that exist in the juvenile system that don't exist in the adult system. I can answer questions, and I have a lot more information I'm happy to share.
Thank you, Ms. Egan. Mr. Frazier, you're up next if you can unmute yourself.
Absolutely. Good afternoon, everyone. Thank you, Mr. Chair, Mr. Vice Chairs, and members of the committee. It's a pleasure in order to testify in front of you all today. My name is Darrell Frazier, and I'm a policy advocate and community engagement manager for the Mental Health Association of Maryland, which is a nonprofit education and advocacy organization. Senate Bill 853 implements a range of reforms aimed at diverting young Marylanders from the youth justice system. Mental health disorders are prevalent among children in the juvenile justice system. A recent meta-analysis suggested that at some juvenile justice contact points, as many as 70% of youth have been diagnosed with a mental illness. Youth involved in the juvenile justice system frequently exhibit elevated rates of substance use and mental health disorders. Many of the studies examined this issue have found that over 2/3 of juvenile justice involved youth have a mental health diagnosis or need. Over 20% have a mental health disorder that could be diagnosed as severe. Common diagnoses include behavior disorders, conduct disorders, oppositional defiant disorders, antisocial behaviors, mood disorders, and the list goes on and on. In addition to youth with mental health needs, we also find youth of color who are overrepresented in the youth justice system. For example, in 2013, while the national arrest rate for white youth was 26.0 arrests to 1,000 persons in the population, the arrest rate for African American youth was 63.3 per 1,000, nearly 2.5 times higher. While the rate at which mental health and behavioral health resources are used in juvenile justice settings is low in general, it is even more deficient for African Americans and other minority youth. For those reasons, MHA, we support SB 853. Thank you.
Thank you so much, Mr. Frazier. Ms. Nelson, you are next.
Good afternoon. I'm Marta Nelson. I'm Director of Government Strategy at the Vera Institute of Justice. Vera is a national nonprofit that works to build justice systems that ensure fairness, promote safety, and strengthen communities. The Juvenile Justice Reform Council engaged Vera to analyze and share Maryland data about children in the juvenile justice system, looking particularly at issues of race, equity, and safety. Vera also shared national practices on the key issues before the council. I led the work for Vera and had the privilege of attending council meetings throughout the fall. The council's recommendations, which are before you in SB 853, impressively take on the breadth of issues facing Maryland children drawn into the juvenile justice system. This soup to nuts approach puts Maryland ahead of its peers who've tackled issues piecemeal, improving some parts of their systems while allowing others to languish. Each of the council's recommendations was informed by data, comparison of Maryland's practice with other states, and the council's shared understanding that youngsters touched by the juvenile justice system are children and must be treated as such. The recommendations that will particularly move the needle for Maryland youth based on data are: 1, setting the minimum age of juvenile court jurisdiction at age 13, except for the most serious crimes. Data shows that 90% of cases filed for children below that age end in dismissal anyway, and that these cases disproportionately target Black girls, who make a quarter of all filings in this age group. Number 2, mandating diversion for most first-time misdemeanors and nonviolent felonies. Maryland's own data shows that children diverted do very well. 9 out of 10 children succeed when they're kept out of the formal juvenile justice system. And finally, forbidding pretrial detention and out-of-home commitments for misdemeanor offenses and technical violations of probation, with exceptions for repeat handgun offenses. Data shows that currently 40% of detention cases and over 50% of commitment cases are for misdemeanors. So these changes will be strongly decarcerative. Data shows as well that Black youth are disproportionately held in both detention and confinement, so this should result in more Black children remaining with their families. I'd be happy to answer any questions that you may have, and I very much support this bill. Thank you.
Thank you, Ms. Nelson, and thank you to Vera. I know Senator Carter, Senator West, and I attended a conference that you helped sponsor with our friends at Pew, and it was very much an educational conference, and we appreciate it. I'm looking around the Zoom room and don't see any questions. So with that, that ends the hearing for Senate Bill. Senator Castley, you have a question. Go ahead, Senator Castley.
Yeah, thank you, Mr. Chairman. I'm sorry, I thought you were looking for other witnesses. I didn't know you were looking for other senators in their questions, so I apologize for being late on the uptake. So I've talked to the secretary before, and he knows my concern about pushing kids through the system, because we've always been told at this committee that juvenile justice is not about punishment. It's about protecting kids and giving them the services they need, whatever that service is, to improve their lives. And so I bought into that hook, line, and sinker. And I totally think I have no problem at all that that's our goal, and that we're not into punishing, we're into rehabilitating. So, but with that in mind, I'm concerned about a couple of provisions. One says the probation, I think, is limited to 2 years. And I know there's been looking through some of the comments that were submitted, I look at how many times adults are kept on probation for more than 2 years. And so maybe somebody can speak to that, because if I keep you, I mean, if you do, I mean, we sit here listening to these kids have mental health disorders, addiction disorders, and pretty much everything else that you wouldn't want to wish on some poor kid. And we're saying, and guess what? Clock's ticking. You got 2 years to recover, Junior. I just, you know, having watched this stuff in the adult side, 2 years goes by real darn fast. And you know, there's that carrot and stick thing that we see so often in the adult system, where I'm not saying lock Junior in a cell, for God's sake, for 3 or 4 years, but why do we just set an arbitrary 2 years? Why not, when your system, all your experts say that you is ready to move on, if that's 1 year, 2 years, 3 years, 4 years, 5 years, 6 years, whatever it takes to get them their mental health treatment, their addiction treatment, their educational treatment, their, you know, that whole panoply of services that you guys offer. Why do we put a deadline on it? I think Ms. Egan, Jenny Egan is trying to respond.
All right, Ms. Egan.
Yeah, thank you, Senator, for the question. One, I just note that probation is not the only option under the Juvenile Causes Act. So currently, commitment is the more serious and elevated consequence for a felony offense, and commitment in the juvenile system is limited and capped at 3 years. And so that's why we did this tiered approach, right? Commitment already in the statute is a 3-year time limit, 2 years, and then 1 year for these misdemeanors or more low-level offenses. And it is because kids are different and time is different for kids. If you think about what 2 years means in the life of a 40-year-old something, that is, for me, the snap of my fingers, right? But 2 years for a 14-year-old is more than 10% of their life, right? Most of them, it is a significant amount of time for a young person. And in addition, lots of the research showed that effective probation interventions for youth actually take about 6 to 9 months. So part of the reason to cap that is not just because a child may need more services, but if after 2 years there's no new offense, they are not continuing to break laws, because that would be a new case, right? If after 2 years a child is not reoffending, has not come back into the system with a new case, then perhaps the juvenile justice system is not the services and opportunities that they need, first. And second of all, it's to hold system operators more accountable. Often our system provisions are very slow in providing those services. And if we want to hold the adults and the systems and the stakeholders responsible for providing quality interventions to young people, we also have to give them those time limitations to say, this is the kind of time you have to work with a young person, rather than just saying, oh, I made a referral.
Yeah, I hear that, but I've sat there, I've sat with the secretary, and see his, I mean, with the computers we have now, and I know you guys, and hats off, I think the one thing that I've been most impressed about with the juvenile justice system is how thoroughly it's computerized, and kids are in there, and the services and the caseworkers, and everything's timed and flags come up. But it seems to me like this is, the 2 year limit says we're really not very confident in our abilities. We truly believe that despite of all our computers and all of our brilliant people, that we still are incapable of actually effectively managing this. Because if I had a doctor who said, look, I'm going to see a doctor for some condition, and he said, look, there's a limit here. I'm going to see you for a year and then you're out. I'd be like, well, what if I'm not ready? What if? I mean, he's gonna say, well, if you don't jack anybody up, if you don't beat anybody up, then I'm going to assume you're ready for life. But this is so much deeper. And these are kids who came into a system because there were obviously major issues in their life that aren't going to be dealt with in the regular school system. And I just find it a shame that I think Maryland can afford to put the right people, the right systems in there. And I got you. If it comes up, if you were to say at 2 years, there's an automatic hearing before a board, at which a board of the juvenile justice system and maybe somebody else from mental health has to sit down and justify why is junior going on 2 years in one day, or maybe do it every year, and review it and don't leave it up to local caseworker. But to just set this hardcore, boom, you're done, junior. Maybe junior needs another $30,000 or so worth of state oversight to really move them along. So anyway, I don't want to belabor that one. The other issue I'm concerned about is it says if junior's conduct out on the main street in front, he could get into the system, but if junior's identical conduct takes place in school, they can't get into the system. I find that just a confusing, no nonsensical matter. If something, why would the exact same conduct, two kids, identical conduct, one does it as he's getting off the bus at the corner, the other one does it 1 minute later as he steps into the school property. But the first guy is in the system and the second guy is not. Why would that be?
Let's let the secretary take a crack at this one.
Well, yeah, that's the one I'm a little confused about, because I don't know that there's a distinction for offenses on school grounds, and I'll see if Betsy can find that. But I did want to, if I could, address some of the comments about the probation limitations. If I could just take a moment. Sure. Setting the limits on probation is also about trying to provide goals for young people. And a lot of our probation orders are indefinite orders. And so there's really no end date in sight for a young person. And we want to be able to provide goals for those young people to say, not only here are the things that you need to do, but this is how long we expect you, to complete those goals. And so it does give flexibility to courts to extend that time, but kids should be able to reach those goals, and we should be pushing them to get those goals, fairly quickly. When we have kids that linger on probation and stay there longer, oftentimes it's for things, ancillary to their behavior or the offense itself, like restitution that hasn't been completely paid. And so these kids will stay on that probationary period for a long period of time, not because they need services, but because there is this one little outstanding thing there that they may not have the ability to do or to perfect. And then the last thing I wanted to say is that, there's a process called net widening. We don't want to give services to kids that need services through the justice system if they need those services, and that's the only reason that they're with us. If that's the case, then we should move those kids into other systems like the mental health system or the Department of Human Services to receive those services, because there is this possibility of technical probation violations. And we know that that's not just a hypothetical thing, that is an actual process that drives a lot of the low-level incarceration. Young kids for low-level offenses that put on probation and then have a technical violation, not that they're a risk to community safety, but they haven't, made one of those particular court orders happen, they can find themselves back incarcerated rather than getting the help that they're supposed to need. So those are sort of the reasons why we want to do that. And I'm hoping I gave Betsy enough time to look up the portion that you were asking about or perhaps Jenny could as well.
It's page 3 of the bill, Mr. Secretary.
Go ahead, Betsy.
Hi.
On page 3.
Hi, everyone. Good afternoon. I'm Betsy Fox-Tolentino. I'm the Assistant Secretary for Community Operations at the Department of Juvenile Services. And I'm here today just to provide some technical information regarding the bill. Specifically to your question, Senator Castley, about the language that narrows the definition of a delinquent act to exclude conduct that is traditionally treated as a matter of school discipline was a recommendation from the council due to the fact that schools have standards of conduct that they have to abide by. And there's a response already sort of baked in to the school system to be able to respond to low level behavior that may occur in school. Additionally, this language already exists. It's part of our regulatory structure, and it is contained in COMAR. So I'll shift it over to Ms. Egan for some more background, but that's sort of the technical pieces of the bill.
Let me hit you though first a second, Betsy. Is it, if it's in COMAR, then I mean that's your regulations. You're asking us to put it into law, so telling you what to do. You know, you set your own regulations based upon what you want to do. But you know, traditionally dealt with in school. In my 4 years in a public high school, dealing with matters in school involved the most brutal, awful, god-awful fist fights of pounding people in the head, which are traditionally dealt with in the public school. And if a principal were to say, listen, I got you on this fight, that's enough. Next time, this is going to the police, and it happens again. They said, okay, one more shot. If you pound another kid's head into the ground and smash their face, you're going to the police. Even though it was committed in school, it seems to me that, you know, there ought to be a strikeout pointed here where the principal can say, obviously, we don't have the ability to deal with this kid, and we're calling the cops. That was an assault, and we're out of here. But what you're telling me is, it's sort of this is a crime-free zone that anything that I want to do on school, you know, step on the school, hey Junior, step on the school property here so I can pound the crap out of you, because it won't go into delinquency. As long as we do that, then we're safe. And I'm like, what would we want to do? Why would we want to have it's like, you know, we talk about gun-free zones. This is a beat-free zone. I can beat you up here, but not over there. And I'm not understanding why we would have, yeah, but it is. It's establishing a hard and fast rule because it's putting in statute. You couldn't waive this. You couldn't, if we put this in there, if it's in COMAR, you can play with it. The secretary can probably override COMAR if he wants to at his discretion. But in here, we're saying under no circumstances that if it's traditionally dealt with in school, which fights are, every school deals with those things traditionally as in every freaking day, then it doesn't go anywhere. And I'm just like, why would you want to put that in the law?
Senator,
if you want to have it as a matter of policy, I'm cool, but I don't get it.
Senator
I think that,
I'm sorry, Mr. Chair. I just
no. I'm just getting back in. Got it. I'm hearing about beat-free zones and things like that. So, all right, let's. All right, Miss Talentino.
Can I ask just one more real quickly, if I could, Mr. Chairman? It's related. I'm just confused because I've heard so many times it's a race equity issue, and I know we dance around that a lot. So maybe hitting the hard one. Is there? I've seen the report, and it does have a disproportionate impact on youth of color. And I'm just wondering if all the experts on this have we made any determination as to whether the disproportionate impact is for reasons anything other than racism? Is that the only possible explanation we have, or are there other issues that we might explain this disproportionate impact? I'm just curious.
All right, excellent. So let me ask this. Let's go here. Ms. Talentino to respond, or do you want the secretary?
Just on the school issue, these are regulations that are contained in the education portion of the regulatory structure. And the language is traditionally dealt with as school discipline. So it's not all conduct. There's conduct that the disciplinary codes are not set up to deal with. And that type of violent conduct, significant risky conduct, would be sent to the Department of Juvenile Services via law enforcement if necessary. But we're talking about matters that are traditionally dealt with already in the school, like a schoolyard fight where no one gets hurt, or maybe a malicious destruction of property where there's some graffiti on a locker. We're not talking about really risky behavior where we see personal injury. But with that, I'll shift it over to Secretary Abed, Mr. Chair, or whomever you like.
Excellent. Let's go to Secretary Abed next. Here you go.
Yes, thank you, Mr. Chairman. And on the issue of race equity, we have done that research, and we have looked at other reasons, what other race neutral reasons could be causing these disparities, and we have found none. We found that race is the factor. That's the linchpin that seems to be connecting these outcomes. And so when we look at the entirety of the recommendations that we have, we used a race equity lens to try to guide our decisions. That doesn't mean that was the overarching or the only thing that we used in making these recommendations. You know, if you look at the recommendations, I'll just sort of make an example out of the first one, minimum age of jurisdictions. You know, the data that was shown by Vera showed that younger kids, these kids are under 13, disproportionately coming into the system were Black and female. Now, we didn't, you know, necessarily say, hey, we're going to put this line because we want to protect only Black females. We took note that that was disproportionate and that we have an interest in reducing that, but it is good public policy to set that lower limit to jurisdiction. It helps all kids. Because we do have an interest in not bringing 9 and 10-year-olds into the justice system. So when you look at these, yes, race equity was a lens that we used to guide our decision-making, and we certainly look to take opportunities to mitigate those disparities as they exist when we did these. But that wasn't the only thing that we were considering when we were making the recommendations.
So, Mr. Secretary, I've been asking for years from your department and others for any studies that could please show us where you've controlled that show that race is the only possible explanation, where we've controlled for things like fatherlessness, age of the mother, education level of the mother, drug addiction within the family history on crime, mental illness, all these other possible factors that we know would have an impact on a young person and negatively impact their lives. Schools attended, which school districts, school zones. I've never seen that. And I would really love to see it, because while we keep we keep getting the general response that, no, it's only because of their race, but we don't, I'm really curious to see that. So I would love to have that. I would very much appreciate it. But when I hear statements made that say that 9 out of 10 people who are successful, the people who aren't put into the system, 9 out of 10 succeed. It's like, well, of course, because 9 people who aren't put in the system are generally successful. So, I mean, you just provide data that would really be wonderful. What's been provided so far is conclusory and really doesn't, to my understanding, give us this committee the kind of detailed information that we ought to have to be making these public policy decisions on juvenile justice. It's just very much lacking. So thank you. Thank you, Mr. Chairman.
All right, excellent. Thank you. All right. Turning to the committee for additional questions. All right. Thank you all very much. Thank you, Senator Carter. Thank you, Secretary Abed, Ms. Talentino. Good to see you all, and I will talk to you all later. See you soon. Thank you very much. All right, so with that, I think Senator Carter, that concludes the hearing. Is that right? Let me unmute you here.
Oh, thank you. I'm unmuted. Yes, that concludes the hearing. So thank you all.
Excellent. Okay, great. So with that, that concludes the hearing for Senate Bill 853. We'll now move on to Senator Sidnor, Senate Bill 905.
Thank you, Mr. Chair. For the record, Senator Charles Sidnor on behalf of Senate Bill 905, which was cross-filed at the request of Delegate Crutchfield and her HB 1121. I will tell you, I had no idea that Senator Carter was introducing the all-encompassing 853 because this bill was built on the same foundation, but much more limited. And instead of the 20 recommendations, this particular bill focused on recommendation number 5 of creating the work group. So I think our committee has heard pretty much all of the testimony as to the importance of the council, the work groups or council's work. So with that, I won't belabor that, but I will say that within the bill that I had introduced, there was I think a drafting error that I would likely correct which has the work group working with the Maryland Public Policy Institute, which is an organization within itself. The recommendation number 5 actually talks about a Maryland Public Policy Institute, not the Maryland Public Policy Institute. So with that, again, I don't want to make anything longer than what it needs to be. I do have 2 witnesses that I'll let speak on the bill, and we'll keep things rolling.
Excellent. Thank you, Senator Sidnor. And I have Mr. Johnson as your primary witness. So, Mr. Johnson, you're up first. The floor is yours.
Thank you very much, Mr. Chair, Mr. Vice Chair, members of the committee. Thank you for the opportunity to testify. My name is James Johnson. I'm with the Department of Juvenile Services. I'm the legislative director, and we are here in support of SB 905. So, and we appreciate the bill by Senator Sidnor. The bill takes that one recommendation, number 5, which asks for a work group to be created, and that work group would really focus on detailing out evidence-based services that are available or that could be made available that would be provided by both the Department of Juvenile Services or, the Department of Human Services. So evidence-based services, as we know, are programs that have been rigorously tested in a controlled environment. They're proven to be effective when there's fidelity to the model, and they're administered appropriately. So this is one way to approach this. There's a commission in Senator Carter's bill, which would do something along those same lines. So we're certainly very supportive of the concept, very supportive of the recommendation. We would ask for a favorable report and would be happy to answer any questions. Thank you.
Excellent. Thank you, Mr. Johnson. Next, we have Ms. Egan. You're up.
Thank you, committee. It's been so long since we were together. Thank you, Chair, and thank you, Senator Sidnor, for sponsoring this bill. I believe that everyone on every member of this esteemed body agrees that evidence-based, facts-based policymaking is critical to good government. And oversight of the juvenile justice and child welfare systems are critically necessary. Just last month, Sequel Youth Services, a private company, closed Clorinda Academy due to widespread accusations of abuse, mistreatment, and lack of programming. Maryland currently has a moratorium on placing children at Sequel, but a child from Maryland left that facility as recently as December. In 2019, Glen Mills School in Pennsylvania was closed after widespread scandal and abuse allegations were made public in the Philadelphia Inquirer. Children from Maryland were some of the last to leave the campus before the facility had its license revoked by the state of Pennsylvania. I mention these programs because they were lauded as model programs and evidence-based in the past. In fact, without a shared and rigorous definition of evidence-based programming, it's hard to dispute bold, unsupported claims of quality service provision. Neither Clorinda nor Glen Mills was using quality evidence-based programming. But it's not just out-of-state programs that fail to adhere to rigorous standards. I would ask all of the committee members to review in your oh so copious free time that I hear you're going to have this afternoon, to review the Attorney General's juvenile justice monitoring reports over the last 5 years. Years after year, JJMU has lamented the lack of evidence-based or promising practices inside DJS youth facilities. In DJS has and will respond that its programs are evidence-based. And I put that in square quotes, not to insult them, but because I respectfully disagree. In their defense, how is that term defined? What evidence supports it? And evidence of what kind of efficacy? The goal of this legislation is to create high-quality, rigorous standards for service provision of programs for children in Maryland, both in mental health, the child welfare system, and delinquency. We need these standards, and we need to be able to share this information. Lawmakers ask all the time what works for kids, but there's no single answer. We know that different kids and different communities at different times need different things. This bill is not just aimed at creating a one-time list of programs that work, but democratizing the tools of evaluation and validation by identifying quality assessments and finding ways to make them more accessible to community-based organizations. For that reason, we hope that you will issue a favorable report, and I'm happy to answer any questions.
Okay, excellent. So with that, that'll conclude the testimony for your bill, Senator Sidnor. We'll now move to the committee for questions. Seeing none, that will then conclude the hearing for Senate Bill 905. Thank you, Senator Sidnor.
Thank you.
All right. We will now move on to Senator Huff at Senate Bill 852. Senator Huff, you're up.
Yeah, thank you very much, Mr. Chairman. Senate Bill 852, the Violent Firearms Offender Act of 2021. I urge the committee to give a favorable report on this. This is exactly the same legislation as passed by this committee last year, amendments and all. This legislation is a result of this committee's hard work last year. We put into strengthening penalties against for crimes of violence using firearms by repeat offenders. We passed this last year. The vote was 10-1 in committee, and on the floor of the Senate, it was 43-4. 43-4. Just like the bill we offered in 2020, this is an emergency bill because gun homicides continue to be unacceptably high in our state, and Marylanders are demanding action. We see high numbers of gun homicides not only in the city of Baltimore, but across much of the state. In my county, here's some examples. In my county of Frederick County, 3 men were charged in the shooting death of a teenage boy in December. One of the suspects is still at large. In June of last year, a pregnant woman and her young daughter were gunned down in the city of Baltimore on a Friday afternoon. The mother was only 23 years old, and the daughter was only 3 years old. In the Eastern Shore of Maryland, a 3-year-old boy was injured in a shooting. The boy was in his bedroom at 8 a.m. when gunfire came through the window in Princess Anne. And I just saw this story yesterday. I'll hold it up. This very heartbreaking story of this 10-year-old little girl who was gunned down on her way to the store to buy Cheetos. Thankfully, as of now, she's survived and she's recovering. But it's completely tragic and outrageous what is happening all across the streets in Maryland. These shootings and murders are happening in broad daylight to innocent and law-abiding people. A poll from December commissioned by Governor Hogan shows broad and bipartisan support for taking action. His proposals, which much of these are built off of, and I know we've got Scott Schellenberger here and Andrew Castley's here from the governor's office to speak further on it, but to show 81% of likely voters in Maryland support this type of legislation. 80% of Democrats support it. Among those, 61% strongly. Just to talk about across the state, the problem, in my county of Frederick County, homicides are up almost 40% from the previous year. In Baltimore City, there were 348 homicides in 2019. In 2020, there were 335. And as of in this year, there's 27 already. So the reasons that we passed this legislation and we put all this work into it last year have not dissipated. In fact, it's gotten worse. Illegal handguns are the problem. Not taking repeat violent offenders off the street is the problem. Criminals are using and repeatedly carrying firearms to commit violent crimes. In fact, 81.4% of homicide suspects in the city of Baltimore had prior records. 44% of those suspects had previous arrests for gun crimes. I remember in this committee in 2018, then Senator Norman asked Baltimore City Police Commissioner Darrell DeSouza how many homicides have been committed in the city by lawfully obtained firearms. The commissioner responded, none that he was aware of. So just to re-summarize what this package does, and this is, as I said, as written by Senate JPR last year, 1, increases the penalties on repeat offenders committing violent crimes with guns. 2, increases the minimum sentences for individuals who repeatedly used a firearm in the commission of a crime of violence. 3, establishes a reentry program for inmates before and after their release to include reentry kits. 4, permits the state to appeal trial court decisions to exclude evidence in cases involving a firearm, including those involving major drug traffickers, kingpins. And last year, I know this was a controversial portion, but last year, Chairman Smith very ably defended this on the floor, saying this expands the opportunity for the state to file an interlocutory appeal on 15 offenses, all gun offenses where the person is a repeat offender. Motions to suppress are very rarely overturned, so if the state is going to go forward with this appeal, they have to be certain that the trial judge made a mistake before there are checks. Number 5, it adds use or possession of a firearm to the list of offenses that cannot be considered technical violations. 6, it changes the use of an assault weapon, rapid fire trigger activator, or magazine that has a capacity of more than 10 rounds in the commission of felony or crime of violence And it codifies the Wynn decision, which said that you have to actively use the firearm in a crime. 7, it closes the drug dealer loophole, which I've talked about earlier, which is in Maryland law explicitly removes those who are dealing drugs and actively using a firearm from tougher sentences. So it closes that loophole. 8, it makes theft of a firearm a felony. 9, it expands the list of crimes a person may not be released on for pretrial release to include people previously convicted of a crime of violence and then are subsequently again charged with a firearm offense. 10, it increases the penalties on people who are disqualified from owning firearms, such as fugitives and those with a history of violent behavior against themselves or others. Current law provides for a maximum penalty of 5 years for persons who illegally possess regulated firearms. This bill would allow up to 10 years for repeat offenders. So again, these are people who are carrying guns, they're not supposed to be, and they're caught for a second time. This is not a mandatory minimum, but allows up to a 10-year penalty. 11, it adds tougher penalties for those who knowingly transfer or loan firearms to people and they have actual knowledge that the person is going to commit crime or cause harm to the purchaser, leasee, transferor, or another person. And I should note that the same provision on long guns was included in the legislation that this body overrode earlier this year. So we should at least do the same on regulated firearms. We know violent crimes by repeat offenders using firearms is out of control in many of our communities. The public knows it too, and overwhelmingly wants tougher laws against these types of criminals. It is time for us to take action. And because of this, we passed this bill last year, almost unanimously in our committee and broadly on the floor. It is time again to pass it and get it signed into law. For these reasons, I urge a favorable report.
Excellent. Thank you, Senator Huff. And we have 2 witnesses. Your first up, your primary witness is Mr. Schellenberger. You're up.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Today is Wednesday. Yesterday on Tuesday, a 17-year-old was shot multiple times on I-83 in the Mount Royal area. Monday, a 12-year-old was shot in the arm using a handgun. We took a break on Sunday because Saturday, a 10-year-old was shot in the chest with a handgun. This is about getting violent criminals off the streets and expanding our laws so that we can take care of that. This bill has nothing to do with the Second Amendment. This bill has everything to do with violent criminals. I support Senate Bill 852, the Violent Firearms Act. I'm going to go through it very quickly. I go through in the order in which they appear, so if you want to turn pages while we're taking a look. But this in one bill offers a very comprehensive approach to the real problem that we have all over the state of Maryland. In 2019, I had 52 homicides, the most I've ever had, the vast majority committed with handguns, the most I've ever had. So this is a great comprehensive approach to do one thing, and that is get bad guys with guns. Number one, for a violation of probation, and you use a firearm, it no longer is a technical violation. I don't know how we ever got there, but it is currently a technical violation, which means JRIO limits it to 15 days incarceration. It clearly sets out what reentry initiatives must be done by the DOC to help inmates get back into society, as simple as things like clothing and ID, and as complicated as things like Medicaid. It expands the type of cases that a state can appeal from when a motion to dismiss an indictment is granted or a motion to suppress is granted. And it allows us to appeal that in a number of firearm offenses that we couldn't have done before. It makes clear that the use of a firearm does not include mere possession. And in fact, that's made clear in 3 different places in this bill to make sure that there's no confusion. So use is not mere possession for a handgun. Use is not it has to be more than mere possession for an assault weapon, and it has to be more than mere possession. It has to be used for the machine gun, making all of those felonies. It makes the theft of any handgun a felony, no matter what the value is. Right now, it depends on the value. It eliminates that bad exception that I have no idea where it came from decades ago, but there was an exception that when you use a handgun while distributing drugs, it was not a crime of violence, which meant your sentence could not be longer. And I have no idea how we ever got there, because so many of the homicides involving a handgun and the use or distribution of drugs. It expands the crimes for which a commissioner may not release an inmate, and puts that burden on the judge the next day if you've been previously convicted of firearm offenses, or you're already on pretrial release for a firearm offense. The commissioner cannot release you. And finally, it changes PS 5133, which is 11 different categories of those who cannot possess a gun, and it increases the sentence if you're in one of those categories and you do get caught and possess a gun. This is a comprehensive, one-stop approach to deal with one very bad thing, and that's bad guys with guns, and I urge a favorable report.
Thank you, Mr. Schellenberger. And now we'll move over to Mr. Castley. You're up.
Good afternoon, Chairman Smith, Vice Chair Wall, Stretcher, and esteemed committee members. For the record, Andrew Castley speaking on behalf of the Hogan administration to support Senate Bill 852, which will increase penalties for criminals who use and repeatedly possess illegal firearms, as well as those who supply these guns to criminals. Last year, the Hogan administration presented Senate Bill 273, Violent Firearm Offenders Act of 2020. The legislation increased penalties for repeat violent offenders with the use of firearms in the commission of a crime. This committee worked closely with the administration in a bipartisan way to come up with a compromise. Senate Bill 852 is the work and product of that compromise, and it passed the Senate last year in a bipartisan vote. Unfortunately, Baltimore continues to experience a public safety crisis, this in spite of the worldwide pandemic. Last year, 335 people were murdered in Baltimore City. 296 of those were homicides, or 88% of them with the use of a handgun. Tackling violent crime remains the top priority of the Hogan administration. Since taking office in 2015, Governor Hogan has dedicated resources to fighting violent crimes, such as providing more than $1 billion for public safety and crime control efforts in Baltimore City, enacting the Enhanced Visibility Patrol Initiative, where state law enforcement officers patrol high crime areas, expanded Project Exile to provide state funding for additional federal prosecutors, pushed a joint strike task force comprised of more than 200 law enforcement officials from 18 allied law enforcement agencies focused on disrupting and dismantling violent crime, created Maryland Criminal Intelligence Network to allow for better data sharing among local, state, and federal law enforcement agencies to better target criminal enterprises. Despite these investments and new initiatives, we continue to see criminal violence rise, and not only in Baltimore City. If we're going to get a handle on the rampant violence, we must stop the flow of illegal guns into the hands of criminals, and we must provide our criminal justice system with the tools to hold violent offenders accountable. Governor Hogan remains committed to using every tool in the toolbox to help stem the tide of violence. Senate Bill 852 does just that. It provides another tool in the toolbox as we continue to remove repeat offenders from our streets. With that, I ask for a favorable report. Thank you, Mr. Chair.
Thank you, Mr. Castley. All right, and with that, that'll conclude the testimony for Senate Bill 852. Turn it to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 852. Thank you, Senator Huff. Thank you, Mr. Schellenberger and Mr. Castley. We'll now move on to Senator Hayes. I see you're here with Senate Bill 752. Senator Hayes, you're up.
Yes, good afternoon, and thank you, Mr. Chair. I missed you on yesterday, and I owe this committee an apology. I thought that was my one and only time before you this session. But I have another bill, and I see Senator West just perked right on up. Looking forward to it. Always good to see you, Chris. Senate Bill 752, I'm introducing in conjunction with the Baltimore City Police Department, and we'll be joined very shortly by Eric, who's the Chief of Staff for the Baltimore Police Department. In 2016, after the investigation death of Freddie Gray, the Department of Justice found serious deficiencies in BPD's supervision of its enforcement activities, contribute to the department's failure to identify and correct unconstitutional policing. The resulting consent decree from the investigations mandated systematic changes in how the department supervises its members and to allow for more accountability and how promotions are handled. It requires a holistic review of each candidate's qualification and inquiries into the nature of complaints and or sustained disciplinary infractions. The law that currently governs promotions is a barrier to achieving that goal. The purpose of Senate Bill 752 is to alter the procedures used by the police commissioner of Baltimore City to award promotional appointments. The current law actually requires that although the commissioner may set certain minimal qualifications, he or she is only permitted to consider the candidate's score on a promotional exam when making these appointments. The department must make appointments from those applications who place within the top 5 positions of the active promotional list. The requirement is referred to as the rule of 5 and does not take into account the possibility that one or even all of those possessing the top 5 test scores might be unsuitable for supervisory positions. In fact, there have been instances where candidates have been deemed unsuitable for promotion, but the department has been forced to promote the candidate anyway because of this rule of 5. For example, if the top 5 candidates of the promotional list all have disciplinary actions, criminal charges, done something against the consent decree, or are under investigation, the department would be required to select the least of the worst. This is not the way to ensure effective and accountable leadership. This bill will allow the BPD, as drafted, to increase the list of appointments from 5 to 20 positions on the eligibility list and empower the department to remove any candidate who is found sustained for misconduct complaint that has received after he or she applied for the promotion, but before a position is available for promotion for that applicant. Termination is a possible punishment for the allegation if he or she were to be found guilty. There is also an amendment that Eric will explain to you in just a few minutes and will provide an overview. The changes contemplated in this bill are necessary to allow the department to comply with the consent decree paragraphs related to promotions, but more importantly, they will allow the department to elevate the next generation of reform-minded leaders into supervisory and managerial ranks, while also promoting a more positive culture of accountability and a better structure of upward mobility in the BPD. It's important to have a holistic view of an applicant looking at their accomplishments on the job, as well as any complaints that may be filed against them. This is vital to ensuring good leadership and the cultural change needed in the department. This bill is a crucial step for police accountability in Baltimore City. Thus, I urge a unanimous vote for Senate Bill 752 as amended, as the amendments have been submitted. Thank you so very much, Mr. Chair and members of JPR.
Excellent. Thank you, Senator Hayes. Good to see you. Sorry I missed your appearance yesterday, whenever it was. All right, we'll go on to Eric. Are you up? There you are. All right, the floor is yours.
Thank you, Chairman Smith, Vice Chair Wall Stryker, Senator Hayes, of course, and other members of the committee. My name is Eric Malassa, and I'm the Chief of Staff for the Baltimore Police Commissioner, Michael Harrison. We're here before you today because of all the reasons that Senator Hayes outlined. Part in making sure we're, bringing up the best in the department is making certain we're looking at a holistic review of every candidate Our rule of 5 restricts our ability to do that. And in talking to our consent decree monitors and the Department of Justice, we've developed a brand new policy in coordination with them and with community input, and even with officer input, in the development of a improved process. But part of that process is ensuring we have the discretion to look beyond just the top 5 names on the list. So the amendments that are being proposed to the original bill, we actually worked with, of course, the bill author, Senator Hayes, and with Senator McCray, who was very helpful in identifying an issue. And that is just making sure that the number that we are able to consider is relative to the size of the overall list. And so we're actually going to be providing those amendments through the process to change it to a rule of 25% in lieu of a fixed number. And so, for instance, we have a sergeant's list that just was produced that has 81 members. 25% of that would be roughly 20. But we also have a lieutenant's list that was recently generated that has 52 people on it. That would make it such that it would be more of a rule of 12. And so for us, we think that's a better baseline. And again, I want to thank Senator McCray and his input into that process. But the other provision that the amendment calls for is to ensure that our disciplinary review committee, in addition to the CRB, can provide us with guidance on folks that are slated for termination. If folks are on the track to being terminated with our department, we cannot strike them from our list. We can only pass them over. And again, if the rule of 5 is in place as it is today, we are at a place where we are continually reducing that discretion of who we can promote until finally it is no discretion at all. And, we're bound to a choice, unfortunately, of who is the least harmful option to promote into the rank of either sergeant or lieutenant. It's not a theoretical exercise. We have faced that reality in the last couple of years. And so for us to ensure that we are pushing forward on reform, making sure that we're promoting reform-minded leadership into the ranks of sergeant and lieutenant, we want to make sure that the department has that discretion, following its policy, ensuring there's fairness and equity into the process, which that new policy does, and also providing an opportunity for meeting our equity and diversity goals, which this would allow us greater freedom and ability to do. So with that, I'll submit to any questions that the chair or the vice chair or other members of the committee may have. And again, Senator Hayes, thank you so much for bringing this bill forward. It's really important to ensuring not only consent decree compliance, but just the quality of supervision being improved in our department in the future.
Thank you for the testimony. We're going to take questions. I'm sorry,
Mr. Vice
Hayes.
Chair, one part of my testimony that I left out, and I apologize, but very importantly, this bill was heard before the Baltimore City Senate delegation and passed unanimously with the amendments. So sorry I missed that earlier.
Got it.
I apologize.
No worries. Thank you, Senator Hayes. We're going to take questions after all the testimony has concluded. So testifying in an unfavorable posture is Mr. Cohen. Mr. Cohen.
Hey, hi, how are you? This is Sergeant Elliot Cohen. I'm with FOP 3. I'm the state trustee. So we're in opposition to this bill. So the sergeant, lieutenant are civil service positions. They're supposed to be objective without a lot of, sort of this political input into these promotions. And by expanding it to a rule of 20, we start going sort of beyond, we open up that area for abuse. If you're taking a test and the first person is less qualified than the 20th person, then I think what's occurring is, you don't have a good test. And the BPD has control over the testing procedures. They decide the questions, they decide the material, they decide the rubric for the oral board. If that test is not getting good people, then the test should be reverted. I do think the new promotion policy that's put in place is a good policy that improves the department. However, it does still leave that control entirely within the commissioner. All the people are assigned to that committee owe their jobs to the commissioner. The committee can be changed at any time by the commissioner, and the policy can be rescinded by the commissioner. And this isn't anything having to do with Commissioner Harrison, but we don't know what the commissioners are going to be like in the future. I've been with the department 8 years, and I've had 5 different police commissioners. So you never know what is going to occur down the line. And the importance here is just that it's supposed to be an objective process, and this civil service would allow that to occur.
Great. Thank you so much for that testimony. Senator West has a question.
Thank you, Mr. Vice Chair. So whether it's 5 or 20 or 25%, it all seems rather arbitrary. Do other police departments in the state have similar rules of 5 or 20 or 25% enacted as a part of the statutes?
To whom is your question directed, Senator
Oh,
West?
well, why don't I ask it to Senator Hayes, and if he doesn't know the answer, you can defer to somebody else.
Yeah, I'm gonna defer to Eric, actually, Senator West. I've had opportunity to work with the city on this Rule of 5 issue, and it's always, when I served the city as assistant deputy mayor and supervising the police department, it's always been a challenge to the administration, but I have not had the opportunity to look at other counties to see what they're doing. Eric, do you have any information on that?
I don't have specific information about counties in Maryland. I would say, Senator West, that part of ensuring that we have a good policy, we try to look at other major cities, and we try to make sure that we're looking kind of comparable to departments our size. That's information we can provide to you in a subsequent.
Okay, well, let me follow up on it then. This morning on the floor, we just passed this bill that would turn control of the Baltimore City Police Department over to the Mayor and City Council of Baltimore City, assuming that a referendum passes in the next couple of years. So I guess my question is, what does that mean in practice? And this is a pretty good example, opportunity to question what it means. This bill would be part of Maryland statutes. If in fact the referendum passes and the Mayor and City Council take over the control of the City Police Department, would this continue to be operative on them, or would it now become the power of the Mayor and City Council to dispense with this rule and alter it in any way they want and enact a city ordinance that would cover it, or directly control the police department and impose these restrictions on promotions in some other way?
Oh, Senator West, it's always a pleasure. You actually just answered the question in your question. So as you stated, the bill that passed won't go into effect for a number of years, possibly, right? And while right now the law of the land is that of the state legislature, and so the city and any changes to any current practices have to be initiated and legislated through the state legislature. Because this is something that is of a priority of the consent decree and of the department, they had to move now in order to correct the problem that exists today. And then your second part, I apologize. The second part of your question is, if we was to pass this now, would this be later obligated to the city of Baltimore? And the answer to that is yes. We have the authority at a later point, if they pass the charter amendment and go through all of the functions, they would have the authority to make changes to this should they choose to.
Okay, great. So this might let's hope, probably will end up being a short-lived bill, and it all gets lateral to the Mayor and City Council once this referendum goes.
Correct. Yes, sir.
Okay, great. Thank you.
Thank you for that. Senator Hedelman, did you still have a question? All right, that's a no. Does anyone else from the—
That was my question.
Yeah, Wes asked her question.
Got it. Figured as much. Anyone else on the committee have a question for Senator Hayes or his panel? All right, thank you, Senator Hayes. Thank you, everyone.
Thank you all so very much.
That concludes the hearing for Senate Bill 752. We'll now move on to the final bill of the day, which happens to be mine. It's Senate Bill 862. And let me pull up my testimony while others are entering the room. This will be a short one. Members of the committee, in almost every jurisdiction, district court judges and circuit court judges can and will quash an outstanding warrant. This bill simply makes clear that that power exists in all jurisdictions. It is clarifying, and there is no opposition. Here's how this works in practice. A district court commissioner issues a warrant against someone who has a previous FTA for a petty crime. That person goes to a defense attorney for assistance. the defense attorney calls the state's attorney and asks, hey, would you agree to quash this warrant? And I'll ensure my guy shows up when he needs to. The state's attorney makes sure the guy isn't dangerous, agrees to not oppose the motion to quash, and the judge quashes that warrant. That's how it already works in the vast majority of jurisdictions. For the minority of jurisdictions who simply want it made clear that they have this power, this bill spells it out for them. I ask for a favorable report. And with that, I will turn it over to State's Attorney Robert Hill. Do I see Mr. Hill here? Oh, thank you. There you go.
Okay, can you hear me now? All right. Thank you, Vice Chairman, and I also want to thank you for your support of this bill. Essentially, when a commissioner issues a warrant, there are really 5 things under consideration. First is there probable cause, and then the next step is this person that's been where a statement of charges has been issued? Does he have a prior FTA or failure to appear on a summons or a citation? If that's the case, then the commissioner can issue a warrant. Other reasons are the whereabouts of the defendant are unknown. Defendant may be in custody in the local detention center, or the defendant is deemed to be a danger to the community. I was really surprised that Montgomery County was not allowing for the recall of warrants issued by commissioners. For years, I'd get the phone call, like the Vice Chair says, and I do my own due diligence just to make sure that this is somebody who's going to show up. Usually the attorney would call and say, hey, Mr. Smith has hired me and I'm going to represent him, and he's going to show up to court. As long as I'm satisfied that he's going to show up and he's not a danger to the community, I'll agree to consent to a recall of the warrant and an issuance of a summons. I was very surprised that my county, Montgomery County, was the only one that was not allowing this. So this just simply codifies and clarifies that the bench has the jurisdiction to do this. I would note that this has been reviewed by the Maryland States Attorneys Association. They are in favor of this bill. John McCarthy, my boss, Montgomery County State's Attorney's Office, is also in favor. And so I would urge a favorable report. This will save people from unnecessarily having to sit in jail to wait to get before a judge, after a weekend or a following day. I think it'll save the county money, and also I think it's fair. Thank you.
Thank you, Mr. Hill, and please give our best to the state's attorney. And now we move to State's Attorney Scott Schellenberger. Go ahead, Mr. Schellenberger.
Mr. Vice Chair, members of the committee, in a complete shock, yes, I am in favor of this bill, Senate Bill 862. This is a practice that takes place in Baltimore County on a very regular basis. When an individual has an attorney, the arrest warrant hasn't been served, we convert it to a summons, or sometimes we just say, let's get a trial date and let's go. This is done regularly here in Baltimore County. It's also my understanding that it's done fairly regularly in almost every jurisdiction in the state. When I saw the need for this bill, I was actually shocked, because we've been doing this in Baltimore County since I was very young, and assistant state's attorney. And when Mr. Hill told me about his problem, I couldn't believe it, but I did go back and research and found that there really wasn't a rule and there wasn't a statute that says you can do it. We were just doing it as a matter of custom. And I do know, I wasn't going to mention his jurisdiction, but I do know my friend from Montgomery County has a little bit of problem with this. This is the most common sense, easy, simplest bill that I've seen in many years down the legislature. And I urge a very favorable report. It's just a no-brainer.
Thank you, Mr. State's Attorney. Senator Giannetti, you are next.
Great. Thank you very much, Mr. Acting Chair, Mr. Vice Chair, members of the mighty JPR Committee, John Giannetti for the Maryland Criminal Defense Attorneys Association. This bill came, I just started as a lobbyist last year for the Maryland Criminal Defense Attorney. And some attorney came up to me from Montgomery County and said, hey, listen, our warrants are being denied not on any basis other than jurisdictional. And we found out since then that even the administrative judge in Montgomery County sent a letter to all the lawyers saying, please don't file any motions to quash a warrant from issued by a commissioner because we don't have jurisdiction and they're going to be denied. Well, as you've heard from the others, this is just part and parcel of really criminal defense practice. It happens every day, hundreds of times a day around the state, and it's what every other defendant in every other jurisdiction expects to be able to have, and that's the judge be able to make a decision as to whether or not that warrant should be quashed. And oftentimes the judge will do it. If they're being denied based on jurisdiction, that doesn't seem that one law is interpreted differently only in Montgomery County. So the MCDAA in their wisdom, we put it into writing. John Carden put it in last year. It never made it out of rules because of the truncated session. This year, we were very happy that Senator Waldstreicher agreed to be a sponsor because this is by and large a Montgomery County issue. And I thank the attorney ASA Hill for coming on because John McCarthy was crucial to making the wording perfect. And so that's why we're able to have everybody together. While I have everybody, I know that members of the committee, you might appreciate this. A lot of you spent your time in the Judiciary Committee before you came over into the Senate JPR. I actually am wearing this tie. You might recognize it. This is actually Joe Valerio's tie. And he gave it to me and he didn't realize I still have it. So I feel whenever I wear this, I feel like that's a good tie to testify in. So I wanted you to know that.
Thank you, Mr. Giannetti. I'm told that it's the chairman's birthday, Joe Valerio's birthday shortly, either today or shortly. So we wish him well. We wish him about happy birthday. Speaking of former delegates, one of the brightest and most effective attorneys in all of Montgomery County, Delegate Mercedes Morales. Go ahead, Delegate Morales.
Thank you, Vice Chairman, and it's great to be here today and to reconnect with so many of my former colleagues and many of my election class, including Chair Smith, Senators Sidnor, Hedelman, Jackson, and West, and obviously one of my closest friends, Senator Carter. This is simply a do-gooder bill, and it also is for our conservative colleagues that are invested in good government bills and are always concerned about judicial economy, like Senator Huff, for example. This is simply a bill that's going to codify what many of the former panelists have already said, has already become normal practice throughout the state of Maryland, with the exception of Montgomery County. All that I have to really add is that I have in my own practice experienced the same very situation with many clients. Despite my repeated efforts and inquiries to the court, we had no recourse for a withdrawal of my clients' warrants. In many cases, it resulted in them actually getting picked up and having to turn themselves in, as we say colloquially. And what this actually ends up happening, what it results in is this individual gets detained by Montgomery County Police, then they get fingerprinted and then released with the same summons that they could have just simply gotten through the quashing of that warrant. Obviously, this is an invasive and an intimidating process for those individuals who haven't been through any kind of judicial or any contact with police. It's a waste of the judiciary resources, as well as detention and corrections. And like I said, this is a practice that's been commonplace throughout the state of Maryland. And for those reasons, I would just simply urge a favorable report. And I want to thank Senator Waldstreicher and his team for acting so swiftly on this bill and getting it drafted in time.
Thank you, Ms. Morales. Looking around the room for any questions from the committee. Senator Carter, go for it.
Thank you, Mr. Acting Chair / Vice Chair. I appreciate everybody's testimony. It's good to see you, Delegate Morales and everyone. And, you know, it's interesting. Scott Schellenberger said this is like the easiest no-brainer bill we'll ever have. No problem with that. But I do have a problem, not about the bill. My problem, there are two problems that I have. One, I'm confused and troubled by the fact that a judge doesn't understand his jurisdiction and his power to quash a warrant issued by a commissioner. That's a problem for me. Like, how could that even be existing in the world? I don't know. I have never come across it. And the second thing is that if some of these warrants are so common sense would dictate that they should be quickly morphed into summonses, my problem is with the power of the commissioner to issue these warrants to begin with. And why are they warrants to begin with and summonses? So I just think these are issues that bear some additional fleshing out beyond this bill. Thank you.
I cut Senator Carter short. I
It's okay.
apologize.
Oh, I think I'm not sure when I got cut off, but I see Mr. Giannetti wants to answer, so.
Okay, let's go to Mr. Giannetti.
Great, thank you. You know, it's funny because we wondered the same thing because it was such a commonplace. And Mr. Hill from the state's attorney's office even testified. He said, I didn't even know this was going on in my own county, right? So it's specifically something that is experienced mostly in the district court practice. And, Senator Carter, all I can tell you is, we have a Court of Appeals with justices on there, and even in they're all the smartest lawyers in the state, and yet they disagree over how the law reads. And so what I think it comes down to is it's not specifically written out that the judges have this power. And for those people who are like students of history of the state of Maryland, they know that the commissioners were given the power to do the arrest warrants in order to take the job away from like the duty judge of the district court. So if you know that, then of course you say, well, then of course the district court judge can overrule what the commissioner has. But it wasn't specifically clarified in that writing. And so Montgomery County just interpreted it, says, well, it doesn't specifically say it, so therefore we're not going to find that we have jurisdiction. And that's why the legislature is the perfect body to make clarifying rules. You have the legislative intent. And it was my belief that this is the legislative intent because it works so well across the state. One more point that you asked, your concern, when I was in the House, Bobby Zirkin and I put in bills about the requirements to be a commissioner. And I'm sure you're not surprised to find out that the requirements to be a judge are much, much tougher than they are to be a commissioner. And so you have a wide range of individuals that we endow with discretion in order to determine if there should be an arrest warrant out there or not. And sometimes they just don't make the right decision. That's all. It's just a matter of just that many 30, 40 different individuals around the state would make different decisions on an individual. That's all.
Thank you.
Right. Thank you. Senator Carter, did you have a follow-up or that was good? All right, Senator West has a question.
It's more of a comment. Thank you. Thank you, Mr. Vice Chair. After all of the difficult bills that we've been dealing with lately, this bill is like a breath of fresh air. And I've been trying to figure why we have a breath of fresh air. And I wonder whether it's because of the presence of Delegate Morales. So I want to say, if she's responsible for bringing this aura of compromise and consensus, I'd like to see you testify before our committee more frequently. Thank you.
Thank you, Senator West. It's so great to see you, and I will take you up on that.
All right, thank you for that. Senator Bailey has a question.
Thank you very much. Might be already gone over, but in district court where I am, we have the judges issue a lot of the actual bench warrants for FTA, where it comes right off the, they do a body attachment as soon as somebody FTAs. Would those also be covered in the same process?
It's okay. I'm going to give this to Mr. Hill, who doesn't always have the opportunity to testify in front of us as frequently. So I want him to.
Well, I saw Scott raising his hand. So if I don't give a good answer, Scott, you can do it. I think this is a different circumstance. This is a circumstance where someone goes to the commissioner directly, and the commissioner they find probable cause, and then they're looking at and this is under the court's article. This is section 2-607, where there are really 4 circumstances where a commissioner can elect to issue a warrant. That would be has this person failed to show up on a prior summons or a citation? Maybe we don't know the address or the whereabouts of that person that's accused. Maybe the person's sitting in a local detention center, or they're incarcerated somewhere, or finally that they're a danger to the community. So this is a circumstance where it happens right there with the commissioner initially, where the charges are initially sworn out. And like Mr. Giannetti said, I mean, this is primarily district court practice. I mean, most of these cases, a lot of them are not of a serious nature. A lot of them are de minimis, may not be very unlikely, victim intensive. And so we just don't want a situation where we want to help judicial economy. We want to save money, and we certainly don't want people spending any jail if this is the kind of case where they're not going to get jailed in the first place. That's if they're sitting in for a weekend waiting because a judge says, well, I don't have jurisdiction over this case. I think that's wrong.
Thank you, and I appreciate your answer. A lot of times, being from a rural county, a lot of things were handled directly through the local state's attorneys, and the local state's attorney through criminal information right into the judge, especially like bad checks, issues like that. They would not go back to the commissioner's office. They just go right through the court. And I was just wondering if that would be handled because a lot of those, I think, would be the same thing. Would make it apparent that if somebody filed an appearance, why do we have to law enforcement go lock them up? So.
All right. Thank you for that, everyone. I really appreciate everyone's testimony on behalf of the bill. That concludes the hearing for this bill, and it concludes our hearings for today. If everyone could meet in the committee room in a half hour for voting, that's a joke. No voting today. Enjoy the sunny afternoon, enjoy the warmth, and we'll see everyone tomorrow.
Thank you, Mr. Vice Chair.
Bad joke.